Who's okay, Senator? Good morning on your bill, Senate Bill 215.
Good morning, Mr. Chairman and committee. It's always really fun when you have to sit on the opposite side of that podium and speak. Senate Bill 215 is a measure that we have been working on for some time. Myself, Senator Mizell, many women of the Women Caucus have been working on this issue to try to bring a level of fairness and parity. One of the things that Senator Mizell did earlier this year is that she scheduled for us to go and visit the women's prison, LWIC, which was a very good educational trip. It had been a while since I had been, and I had not been since they had been moved to Jetson since the floods of 2016. And it was very enlightening to hear many of the stories of the women, and many of them that we spoke to seemingly was kind of caught up in part of this situation here. This bill actually deals with expert testimony, and y'all may remember this from last year. We were here last year. We brought the bill. There was a lot of opposition to the bill, which would allow for those victims or survivors to actually be given the opportunity to have expert witness to validate the reason for the crime or what may have transpired. And because of the opposition, we decided that we would take and pull the bill back, and we would study it in the interim. And we did. We worked on this bill. I thought finally we had gotten to a place where we were in a good position, and that we had worked through a lot of the concerns and a lot of the issues. At the last meeting that we had, the study commission hearing, I was asked the young man who was representing the DA's association if they were okay with what the final product looks like. And he said, to my knowledge, yes, we are okay. A week or so later, after the bill was filed, I found out that they absolutely were not okay. So we again began to attempt to work on amendments to try to put the bill in a posture that we can agree upon. So what I would like to do is put forth the amendments that has been offered. It's my understanding that I don't know if we still have if we still come to a level of agreement on the issue. But what I do know is many of the letters that I've read, many of the women that I have met, many of the stories that I have heard, I believe deserve the opportunity to have a chance to be able to provide this level of testimony and be able to have the fairness in terms of what occurred in their case. And so with that said, I'm going to ask Mr. Stas, Moraz, and you guys are receiving the amendment, to go through the amendments because I know that he worked extensively on them, and I think he can explain them a lot better than I can.
And Senator Barrow, just real quick, just to refresh the committee's memory about this bill, like what's a real life example that this bill would affect, as far as someone committing a crime, a victim? Can you give us just a hypothetical of how this would apply?
So the way that I see it, not what I've heard, but the way that I see it is, and I hate to use this scenario, but a woman who may have been in a scenario where she's been repeatedly beaten by her husband or significant other, and then, one day something occurs, and not at that moment, but she may, come back, or there may be something else where she has an accounting with that person, and she snaps. And I hate to use the word snap, but she snaps, and she hurts them or she kills them, and she ends up being incarcerated and not having the opportunity to have an expert witness to talk about the trauma that has happened to her that led to that situation, this bill will allow that to be added and be a part of that discovery, I guess if that's what they call it, or be a part of her testimony.
So in other words, in defense of her case, she could bring in an expert witness to testify that
They can
she was
explain.
traumatized and that should be a consideration on her guilt or innocence.
Yes.
Okay, why don't we go ahead and go through the amendments? Did you want the staff to walk, or do you have someone there who can?
Yes. Yes.
Yes, sir. Could
Yes.
you introduce yourself for the record and tell us about the amendments?
Absolutely. Good morning, Chairman. Good morning, Senators. So my name is Stas Moroz. I'm a law professor at Tulane University, and the specific program I work in is called the Women's Prison Project. We are a clinical program. We represent survivors of intimate partner violence who are wrongfully incarcerated or excessively sentenced for conduct that they committed as a result of abuse or trafficking. So this is we see a lot of these cases, and we work on a lot of these women's cases. And, there are women who are right now in their 70s, grandmothers who are in prison as a result of abuse and don't really have an avenue to have their cases heard. So
Let me ask you this: Why couldn't a judge let this expert testify? Couldn't he do a Doe-Bear hearing and determine whether or not this expert would be qualified to testify in the case?
That's a really good question. Right now, there's a rule that would allow expert testimony about domestic violence, but it's only in support of the very narrow self-defense framework we have today. There is a rule that says that otherwise you can't bring in experts to talk about someone's state of mind if you're not putting on an insanity defense. So I think Senator Barrow gave one example of how this legislation would apply. Another scenario is where, for example, a woman who's a survivor of domestic violence has been in an abusive relationship for several years, and she's been beaten over and over, and her abuser demands that she go along to commit a robbery or something like that. She's the driver. We currently have a duress defense or a compulsion defense in Louisiana, but it only applies if the person who's forcing the conduct is physically present at the time it happens and is making a threat of great bodily harm or death. And so what we see, as experts in domestic violence, what we see is sometimes those threats have been made over a period of 2, 3, 4 years. So they're not always going to say in that moment, drive the car or I'm going to kill you. But every time they have, refused to comply with the demand in the past, they've been beaten. So in that situation currently, expert testimony would not be allowed because there's an evidentiary rule that says that you can't bring testimony about someone's state of mind in unless you're saying, they're insane. So Senator Barrow's bill would modify the justification defenses, which to account for the dynamics of abuse and trafficking, and it would allow expert testimony in support of that.
So it's not just to allow expert testimony; it also creates a defense to the crime as well. That's what the bill does.
It would basically create a tailored duress and self-defense defense for situations involving intimate partner violence, sexual violence, and trafficking. So the problem is under the current defenses, there's no real opportunity legally for the jury or the judge to hear all the considerations of abuse outside of the very, very narrow sort of self-defense standard we have today.
And then the testimony would be up to the judge or jury to decide whether or not it's persuasive.
Exactly. There's no requirement that the judge or jury believe any testimony. The other side could get their own expert to rebut the testimony if they don't believe that there was actually, a situation of abuse or that it was actually relevant to someone's conduct. The other thing we've seen, which is why expert testimony is so important, so there was a 2018 case called State v. Curley. There was this woman, Katina Curley. She was abused for years. There was witnesses. There were police reports. She ended up getting convicted of second-degree murder. Her attorney didn't consult with an expert. And the Louisiana Supreme Court in 2018 issued a decision saying that, and there's basically a consensus on this issue across the country, that because her attorney didn't consult with an expert, the jury wasn't in a position to understand the unique dynamics of abuse. And so the Supreme Court ended up vacating her conviction. She got a new trial with an expert. She was acquitted, and she's now on the National Registry of Exonerations. But the issue is that decision only came down in 2018, and a lot of people, their convictions had already been final for a long time at that point. and so they can't come back into court under that. As an example, Ms. Taylor is here. She's sitting right behind me. She was in prison until a few years ago. She applied for the same consideration as Ms. Curley, but the court said, your case is too old. We're not going to look at it. So she was only able to get out through clemency, which is a very rare process.
So why don't you take us through the amendments and tell us what you're trying to do here?
Yes. So the amendments today I know there was some concern before that the legislation was broad and it might apply to people other than, women who are domestic violence victims or victims of trafficking. And there's a very direct connection between that abuse and the conduct. So the amendments narrow the legislation to make sure that it really only applies to the people that Senator Barrow has in mind. So the way the defense works is if the alleged victim of the situation is actually the abuser or the trafficker, the survivor could raise the defense and bring an expert testimony showing a direct result between the abuse and the trafficking and the offense that she's charged with. This language of direct result is already in other justification defenses in Louisiana. There's already a defense for human trafficking victims, but it only applies to charges like prostitution. And there has been a national study by an organization called Polaris about how different states approach defenses for trafficking victims. And they looked through the different standards and languages and looked at which ones were broader, which ones were narrower. They actually concluded that the language in this legislation, the direct result language, is too narrow. Like it wouldn't apply. It would only apply in extremely limited circumstances. So that's the standard we have here. It's a very modest, limited standard. And Senator Barrow wants to tread carefully and make sure that this doesn't apply to anyone unintended. So it would apply in that situation to charges against the abuser or trafficker. And then the other scenario would apply is it would allow a survivor to explain if her conduct was the result of coercion or force by her abuser or trafficker. So if an abuser or trafficker says, I need you to pick up those drugs for me, and there's been a history of violence towards the survivor, she could bring in expert testimony and evidence to explain why she felt like if she didn't do that, she was going to be at serious risk of danger. So that's what those amendments do. And then in terms of looking backward, because I think there's been some estimates that there are about 30 to 50 women who are currently in prison, right, who are affected by this. In terms of looking backwards, all it would really do is it would allow people who have claims like Ms. Curley did. That's the woman who was exonerated because her attorney didn't consult with an expert. It would allow people like that to bring a post-conviction claim into court and explain how an expert would have made a difference in their case, or explain if there was significant abuse that was left out. Like we've seen cases where there were police reports showing, corroborated with physical evidence, like strangulation marks on the survivors' necks, weapons that were used, injuries from knives, and the jury didn't hear any of that. So it would allow people who had cases like that to have one shot at coming into a court and saying, look, this is all the evidence that wasn't presented. It would have made a difference. The court would have to find that it would have made a difference. And it also allow the court to consider if there were myths or stereotypes about domestic violence that were relied on that affected the reliability of the verdict. For example, we always hear, why doesn't she leave? She could have just left, right? But it's been shown that's actually the most dangerous time for a domestic violence victim, leaving her abuser. That's actually when a lot of these cases happen, when survivors try to leave their abusers and they're prevented. So that's looking backwards what it would do. And it would allow for some sentencing relief as well. It allowed judges to have an opportunity to make a finding that the sentence is harsh, and that the intimate partner violence or trafficking wasn't taken into account.
Thank you. Members, any questions about the amendments? Senator Abraham.
Okay, of course, I'm not an attorney. So, number 9 on the amendment, time limitations, exceptions, prejudicial delay. You're saying
Amendment number 9?
this amendment, Amendment 12.
Okay.
And then number 9, I guess it's part 9, I guess. right?
Oh yes,
Second page.
Yes.
Second page. Okay, so you're saying that
Third page.
post-conviction relief should not be considered after 2 years.
that is the standard we have to. I'm sorry,
But that's
Senator.
what you put on there. And then am I to read that? I'm just looking at this amendment. Part C under 4C. Okay. How does 4C and this time limitation here, how does that work? Those two?
Yes. So, Senator, the current rule is no one can apply for post-conviction relief after 2 years of their conviction being final. And so that's what's currently in the law. And then if you look at page 3, the subsection 7, the part that's underlined.
Okay, wait. Page 3. Oh, okay, I see. All
So
right,
basically, right. So there are currently 6 other exceptions for when you can apply outside this 2-year period. Like one is when there's DNA evidence that comes up. The other is when there's a claim of factual innocence. That's legislation that was passed a couple of years ago. So it would just create one more exception. So if you qualify for relief under this law, you could apply for post-conviction relief outside of those 2 years. So the typical rule is
Okay, but does part 4C, does that play into the way you get post-conviction relief?
Yes, exactly. So
That's what you're just talking about.
Yes, exactly. So Part C would say they're making an exception to the typical 2-year rule. And then if you look on page 3, Article 930.8, that's where that 2-year rule is found. So
but what is the exceptions again?
Currently there's exceptions for newly discovered evidence, for DNA that someone discovers, showing their innocence later in the trial, if there's some other sort of factual innocence based on scientific information. So there's already 6 exceptions to this rule in our law, and this would just create one exception if a survivor is in a situation where, expert testimony wasn't presented. She can say she gets one shot. It doesn't guarantee that she'll win. It just means she can file without being blocked by the typical 2-year time limit.
How many people would this affect, would you say?
So the estimates that we've seen in terms of people who are already in prison is somewhere from 30 to 50. I will say there was a report released. There was legislation in New York along these lines in 2019, which New York has a larger prison population than Louisiana, of course. And it affected 40 people. So I expect it would be, just based on that we are a less populous state, we have a lower prison population, it would be less than that in terms of people who are currently incarcerated.
Okay, thank you.
Thank you, Senator. I see no other questions on the amendments.
I'd like to offer up those amendments.
So at this time, Senator Barrow moves that we adopt amendments 849. Any objections? Seeing no objections, those amendments are adopted. Okay, back on the bill, we have some people who would like to speak. Do y'all have anything else
What's
you
the
would like to
amendment number
present?
again?
849.
Okay, I think I have the wrong set then. Okay. Thank you.
That's what was 849 is what was passed out.
Okay. Okay.
Is that the correct amendment that you were offering?
Yes. I think I got the initial set, and I think they made a correction to it. Another correction. But that's fine.
So those amendments are adopted. Did y'all want to present anything else? Ms. Ray, did you want to say anything?
Yeah, I'll go ahead and just speak while I'm here. I have a green card in already. Mary Patricia Ray on behalf of Louisiana Survivors for Reform. You're going to hear from directly impacted people, and I don't want to take up much time with the committee, but because a question was asked about the types of cases that would be impacted, Senator Barrow mentioned that on her visit to LCIW, they met many women whose cases may be impacted. That's not a guarantee of post-conviction relief. Rather, they would be able to apply for it. Over the last year, you all heard a bill that was not as narrowly tailored last year. We did not bring that bill to a vote. And I just wanted to take a minute to brief the committee on everything that has happened to work on this bill since last year. Senator Barrow, first of all, picked up a great co-author in Senator Mizell, who is, of course, a member of this committee. She also held several task force meetings that were attended by all stakeholders to discuss the components of this bill. The components of this bill were presented to the Human Trafficking Commission, which unanimously approved this legislation in concept. It was also discussed by A.G. Landry's sexual assault task force, and we had a great conversation there with many people in support. They don't take a position, but there was no opposition to that bill in that task force. We've picked up lots of community members along the way who want to support this bill, including conservative women's groups that are here to testify today. We've brought constituents from every single one of your districts. We've sent hundreds of emails to you, and we've improved this legislation, even though at the last minute, the only opposition to this bill came from district attorneys based on the fact that it would affect women retroactively that are in prison and should not be there. Those cases, the transcripts from those cases, I can see why district attorneys would be concerned about the image that may come out if some of these cases do get post-conviction relief, because frankly, it doesn't look great. That concern should not stop us from righting a wrong and making sure that that wrong doesn't happen again in the future. And so before I conclude, I just wanted to give you a few more examples. In one case of a woman who was convicted of second-degree murder that would probably be affected by this bill, prosecutors accused her in open court of loving her boyfriend more than her children, and they told her that she was a terrible mother. There was no evidence of her abuse presented, and the father, who was involved in the situation, received a sentence of 30 years and got a plea deal. She's spending life in prison without the possibility of parole. This bill would prevent that from happening again. It would not mean that anyone gets a free pass out of prison. It would mean they get a fair opportunity to present the evidence. In another case, a woman shot and killed her husband, who attacked her during a custody exchange of their toddler in the middle of the day in a Walmart parking lot. She was convicted of second-degree murder 3 years later, and the prosecutor tried to paint her as the abuser in the situation in open court, calling her cold and calculating, a sociopath and a textbook narcissist abuser. He presented evidence that abused people don't attack their abusers. That kind of myth being presented in court without any evidence to rebut it is exactly what this bill would prevent. Again, doesn't mean this woman would not spend time in prison. It means that she would be charged appropriately, convicted and sentenced appropriately. And one last one, a defendant and her co-defendant were arrested after being sex trafficked as a teenager by a man twice their age, who kept all the money that they earned. Yet the press described, based on evidence at trial, that she was a former exotic, based on no evidence at trial, that she was a former exotic dancer or former stripper who conspired with her boyfriend to commit a robbery and a murder. Until she agreed to a plea deal that required she testify against her co-defendant, she was being charged with first-degree murder. And there was never any proper evidence that she was trafficked at trial. Again, we're not saying people who commit crimes shouldn't be punished for those crimes. We're saying that they should be appropriately charged and appropriately sentenced, and that is all that this bill would do. It doesn't give anyone a free pass or say that we're not accountable for our own actions. Instead, it makes sure that everyone is accountable for their own actions, not someone else's. Thank you very much.
Just real quick, so the post-conviction relief exception with the amendments goes back indefinitely? I mean, there's no time frame on that?
Well, they only have 2 years to apply for it.
But if we pass the amendment,
Right.
I believe that you could go back further than 2 years, correct?
Yes, that's true. Yeah, you can apply for post-conviction relief outside of the 2-year period. You would get one chance to do it. If it fails, it fails. There are things that we've had such, like, there used to be the newly discovered evidence provision in Louisiana used to be like this. Like, if you find new evidence at some point in the future, you can go back into court now and apply for post-conviction relief. So that's not like an unprecedented scenario, but correct. If someone's conviction is 25 years old, they could go back into court. And just as an example of why I think that's really important in these situations, I think, we still have a long way to go, obviously, with domestic violence. But where we were at 25, 30 years ago is a whole different situation. And so those cases are where the wrongful convictions are most likely to occur, like in Miss Taylor's case, one of the jurors during jury selection, when asked if it was okay to hit a woman, this man ended up being the foreperson of her jury, said, a nagging wife, then maybe you could justify slugging her once, And so the problem is if we don't go back to those older cases, we don't go back to the cases where the stereotypes are the worst.
And so I guess what you're trying to do is capture people who are in jail now, but moving forward, I guess you could just have the 2-year time period and accomplish your goal.
Exactly. And there would be no reason not to just apply in that 2-year time period moving forward, because you would now have this basis for post-conviction relief, and you'd have this curly case that already allows you to make a claim based on not having an expert.
Okay, thank you. We have a lot of witnesses here who are interested in both talking and expressing their support of this bill. I'm going to call the witnesses up, and I'm going to ask you to please limit your testimony to no longer than 5 minutes. Not that we don't value your testimony, but I want to give everyone a chance to be heard who wants to speak. So I'm going to call some of you up right now who would like to speak, and then I'll read the other cards. Natalie Sharp, are you here? She's here in support, would like to speak. Katie Hunter Lowry is here in support, would like to speak. Amanda Tonkovich is here in support and would like to speak. Michelle Johnson is here in support and would like to speak. Lemmy DeSalle is here in support and would like to speak. Good morning. I'm going to go ahead and read some other cards as these people are making it to the table. These are people who do not wish to speak but are here in support. Kevin Fitzpatrick, Andre Winbush, Catherine Hackenberger, Sheila Kane, Ryan Haney, Logan Wolf, Caitlin Joshua, Brittany Dantzler, just says Jackson, Lynetta Terrell, Julie F., Emily Abair, Eva Lassane, Riley Young, Julia Luitzes, Josephine Orlando, Michael Cahoon, Roselle Moran, Samantha Kennedy, Rose Preston, Azara Lewis, Ari Orno, Tasha Williams, Will Lewis, David Cook, Brian Forsyth, Laverne Matthews, Mabel Woods, Denise Davis, Ann Bradford, Alexis Cooley, Jennifer Ajaquin, Diana Bruce, Clyde Michael Comine, Sarah Samillan, Abigail Green, Deborah Renz, Olivia Woodall, Tanya McCullum, Derek Latham, Arian Melanson, Regain Mathis, Hera Grodell, Reverend Alexis Anderson, Louis Malvo. Also here wanting to speak in favor, Connie Lewis, Marcus Patterson, Lene Richardson, Tommy Jackson, Morgan Lamondre here in support would like to speak, Chloe Brubacher here in support would like to speak, Sarah Whittington here in support would like to speak, Mariah Wineski here in support would like to speak, Breachers Taylor here in support would like to speak, Edna Gibson here in support would like to speak, Nyla Starks here in support would like to speak, Mary Patricia Ray has already spoken here in support, Gabrielle Perry here in support would like to speak, Letitia Payton here in support would like to speak, Taylor Robinson here in support not wishing to speak, Reverend Vander Deck here in support not wishing to speak, Pearl Ricks here in support, Hannah Duke here in support not wishing to speak, Scott Payton here in support, Shay Foster, Peyton Rose Michelle, Bruce Riley, Monique Blossom, Peter Robbins Brown, Ronald Marshall, Charmaine Casipio, Will Harrell, Brandy Melissa, Maxwell Cardulo, Nisha Sheedy, Chloe Dimon, Kayla Gittin, Charles Amos, Tom Costanza, Courtney Holden, Matthew Green, Samika Miner, Chico Yancey, Chris Kaiser, and Rachel Calvaruso. And we received 26 emails in support, which will be made part of the record. And so I'd ask each of you to try to Not duplicate each other, limit your testimony. I'd said 5 minutes, but as many people as I have, I'd ask you to try to keep it to 3 minutes. We do value your testimony. So whoever would like to start, please introduce yourself and go ahead.
All right. Good morning, everyone. My name is Amanda Tonkovich. I am a longtime survivor advocate. I work extensively for the past 15 years with victims of domestic violence, sexual assault, and human trafficking. I've provided counseling. I've gone to court with folks. I help folks make police reports, and I get to see people through their whole process. And usually we see our criminal legal process working, but a lot of times we don't. And I've worked with a lot of survivors that unfortunately have experienced really extensive histories of abuse. And we're talking about, multiple instances of being strangled, choked by their intimate partner, having guns pulled on them, really, really dangerous situations. And they try to fight back, right? Which I think any of us has the right to do when we're faced with violence. And then they end up being the one who's criminalized. I accompany survivors during forensic medical exams, which is an exam you get after you're a victim of a crime. I've seen survivors handcuffed to the beds while they're getting CAT scans for strangulation wounds, things like that. I've seen survivors experience extensive abuse, finally defend themselves, and then again, they're railroaded into the criminal justice system. So, again, in domestic violence, context is everything. I think there's a really good example when we look at gun violence, right? If a civilian shoots somebody, that is a crime, right? If someone in the military shoots someone, we see them as a hero, right? So that context really matters. And so all we're asking is to bring this context into court, because if you've been abused by somebody for years and months and been strangled and been, brought within an inch of your life, and then you finally stand up for yourself, we don't want you, and we don't want to waste our criminal justice resources on that. Louisiana is one of the most dangerous places for women to be killed by their intimate partner. We have one of the highest rates of that. So when a woman protects herself, we need to be there as a community to stand up for those women and to, give them that opportunity to tell their full story and just to get to the truth. I think all of us want our criminal legal system to get to the truth, and that's what we're asking with this bill. So we really appreciate your consideration for your support.
Thank you. I see no questions. Please proceed.
Good morning, Senators. My name is Katie Hunter Lowry. I'm the lead organizer with the Louisiana Survivors for Reform Coalition. I am here because victims of abuse need support, but too often we are not believed. I was raped by a man that I was dating, and I didn't report because I knew it wouldn't be believed because it was a domestic incident. I have lived with so much shame from that experience. So much was taken from me. And I always thought of myself as a person who would fight back in that situation. But I blamed myself for years for what happened to me because I didn't fight back. I tried to stop him, and when I couldn't, I just had to wait till it was over. But now I know that if I had fought back, I could be in prison right now. I could have gotten a life without parole sentence for acting in self-defense against my rapist. There are legislators in this building who have told me that maybe I wouldn't have been raped if I had had a gun with me. But when we hear the stories that you will hear of BZ and Edna and so many other women, survivors understand that the choice you then make is 20 or 40 years or life behind bars. When women are killed by their abusers, we name laws after them. But when they do what they need to do in order to survive, they are treated not as victims, but as offenders. The Justice for Survivors Act is a necessary piece of law, but it is also a signal that Louisiana lawmakers want victims of abuse to be cared for. It is truly appalling that we have worked so long to compromise on this bill and that our District Attorneys Association will not support it. This bill would just make sure that the reality and the history of abuse and violence is brought into the light. Thank you. That it is brought into the light for cases going forward and for cases that need a second look. we really have to question what our DAs and our court systems are for when women are coerced into a crime by an abuser and then she gets more time than he does. Many of y'all have campaigned on protecting victims of crime, and to really mean that is to vote yes on this legislation. Survivors should not have to choose between prison or death. We ask for favorable passage, and I want to let y'all know that today also happens to be our 3rd annual Survivors of Violence Lobby Day. That is some of the ruckus that y'all hear in the hallway. It is really amazing to be able to speak on this bill while we have the presence of so many survivors and victim loved ones here in support from across the state, and we hope that you come speak with us and your constituents in the rotunda this afternoon. Thank you.
Thank you for coming today and telling your story to us.
Thanks, Senator.
Please proceed.
Michelle Johnson. I am the chair of the Human Trafficking Prevention Advisory Board. I want to thank you all for hearing this bill today. And I also want to thank you all for the passage of the Michelle Johnson Act that happened last year, along with the LDAA support. I want to thank you all. I'm in the process of expunging my records still. It's, very traumatic. So I want to start off with last year. I was testifying in this committee, and when I left, I heard that I should go back and watch the bill that was heard after the SB 148, I believe. And when I watched, I was like, oh my gosh, this recommendation would be like sufficient to prevent the need of post-conviction relief. For survivors. Myself, whenever I was going to court and I told the prosecutor that I was a victim of human trafficking, I told my attorney and everyone, and it kind of fell on deaf ears. And so I just wanted to say that if this bill was in place, I would have never been incarcerated, along with other survivors who are often incarcerated also. I ended up doing multiple years. I had several hard labor sentences. I was a victim of human trafficking, dealing with a lot of medical issues. I had to have surgery while I was in prison, and it was the most scariest thing because I was told I was a victim and I had serious medical issues going on. There was no place for me to go as far as housing. So when I was released, I was on parole. I had all these fees that was associated with that. So going from trafficking to having to pay fees, it was very hard for me to manage. We have survivors who are currently incarcerated. One of a victim who was trafficked as a teen. She acted in self-defense against her trafficker. He was 47, she was 19. And she is currently in prison doing time for his murder. I personally had guns held to my head. I was raped several times. My trafficker, if I did not do what he told me to do, I suffered immense, just the atrocities of what he did to me. Victims are often forced to participate in the recruitment and advertising of other victims. I personally suffered that whenever I was recruited into sex trafficking and trafficked by my pimp when I was 19. My wife-in-law, who is considered the girls that's trafficked in the stable with you, she was 16, and she started posting my ad. And then, of course, after I was brainwashed, manipulated, and coerced, I started posting ads of the next girls. Sometimes those crimes could fall under pandering, which is another form of human trafficking. And we have victims who are being charged with those crimes. And they're honestly not at fault. They're forced to post these ads. We're forced to recruit. If you do not do so, you will be punished, either beaten, starved, or sold to the next trafficker. So I support this bill. And so does the Human Trafficking Commission. It was a recommendation that came out of our subcommittee, and we had unanimous support, as Mary Patricia mentioned earlier. So I'm asking for support to pass this bill to help trafficking survivors like myself and those coming out of the life.
Thank you for your testimony. There are no questions at this time, so thank you again for coming. We're checking in the hallway to see if there's anyone else who had submitted a card that wanted to speak. Is there anyone in this room right now who submitted a card and checked that they wanted to speak? If so, if you had submitted a card, I'll have three of you come on up. Okay, ladies, if you could, you can start here, Ms. Whittington, and go across.
Good morning again, Sarah Whittington with the Justice and Accountability Center. We do serve on Senator Barrow's task force, and I will limit it so that there's plenty of time for the survivors to speak today. But we are in support of this bill, not only for the rights and the redemption that it could provide for survivors, but also because it goes beyond necessarily post-conviction relief for a lot of these individuals. And if they've previously had this on their record, we know and understand that a lot of these individuals face significant barriers as part of their reentry. So even if offered the opportunity to come home through this bill or through some other means, we know that access to housing, employment, and reunification with their families can be serious barriers that they have to overcome. And we look forward to this Justice for Survivors Act to help them access their release initially, but then also have the funding and the support in place so that they can have successful reentry as well. Thank you.
Thank you. Yes, ma'am.
My name is Edna Gibson, and I'm one of the ones that happened to 1986. I was doomed from the beginning. When I first was arrested, I was told that I was going to get a life sentence without parole, probation, suspension of sentence. And I wanted to not believe it, but it happened. I stayed incarcerated for 32 years. I've been out almost 3 years now. The governor granted me a pardon. But in that time, in my time of incarceration, I knew there was something to help me, but nobody was listening to me. My attorney didn't want to bring up domestic violence. He said because nobody ain't nobody gonna believe that or whatever. So he didn't want to use that as a defense. Then, when I went before a jury, I said, okay, I'm gonna get some relief now. I went before a jury. It was 10-2, a 10-2 vote. It's just like, because I didn't listen to my mom at the time, she told me to get out of there, but I stayed. And people always want to say, why you stay? Because I thought I was in love. But I was in love with my abuser. I'm not here to talk bad about men and women relationships. I'm talking about there's a problem. And I see today that something is being done about it. Because in '86, they didn't want to hear about it. But this is how far we have made it. In 2023, domestic violence, the abuse that you have to go through, the misconceptions. But I was doomed from the beginning. And why can't I get back? Nothing. I was locked up for 32 years away from my family. Everything they had to offer in prison, I took it. And if it wasn't for the governor being so generous to sign me a pardon, I'd still be there right now. With somebody speaking on my behalf, but I can speak up for other people. Mm-hmm. The other women, we need this. That's all I have to say.
Thank you, ma'am, for your testimony. We appreciate it. Yes, ma'am.
Good morning.
I'm sorry. Senator Mizell had a question. Excuse me 1 second.
Hi. Thank you, Mr. Chairman. You were doomed. You're not doomed. You're doing something now to address all of that. So I just, you broke my heart when you said you were doomed. That's just, don't leave here feeling that way, because I feel like you've touched a lot of people in this room. And anyway, we're listening to you. Okay, we hear you. So I couldn't let you say you were doomed and leave here with that thought.
Thank you,
Mr.
Senator.
Chairman.
And I'm sorry, once again, tell me your name so I can.
Edna Gibson.
Okay, thank you, Ms. Gibson. Yes, ma'am.
Good morning. My name is Leanne McCallum DeSell. I'm here as a survivor of sexual violence, domestic violence, and stalking. But I'm also here today as an expert in human trafficking in the human trafficking field. Over the last decade, I've conducted research, implemented federally funded human trafficking programs such as the New Orleans Human Trafficking Task Force and the Louisiana Child and Youth Trafficking Collaborative, and have provided training and technical assistance to human trafficking practitioners across the United States. I've supported case managers and care coordinators throughout Louisiana on hundreds, literally hundreds of cases of human trafficking of adults and children. And throughout my career, I've seen the unsettling theme of criminalization of some of Louisiana's most vulnerable residents, and those are victims of crime such as human trafficking. And that's why I'm here today to support this bill. As you've heard from my colleagues in parallel movements and from survivors, criminalization has become a common occurrence in Louisiana. We've been a leader in the country in our response to human trafficking and advancing legislation that supports victims, but this particular topic of criminalization continues to be a challenge, and this is an opportunity to advance. When many people think of human trafficking, they think of white vans, they think of kidnapping, but in reality, the vast majority of traffickers are taking advantage, they're controlling and manipulating vulnerable people. It can be domestic abusers who emotionally control and coerce their partners into providing sex. It can be friends and family who trick their loved ones into being a getaway driver. Pardon me. Or it can be street-level gangs who force their youth members to sell drugs. In my career, this misconception has led to human trafficking victims, people we know are victims of crime, who don't recognize that their abuse is trafficking, being mislabeled as criminals rather than victims. The Trafficking Victims Protection Act of 2000, which is the federal U.S. human trafficking legislation, is in theory supposed to protect victims from prosecution for crimes as a result of their trafficking victimization. But as you've heard from survivors and will continue to hear, this is just simply not the case in reality. There have been several studies that have highlighted the high rate of criminalization of trafficking survivors. According to one study by the National Survivor Network, of more than 130 survivors, 90.8% had been arrested at least once in their lifetime. So that's 9 out of 10 survivors of trafficking had been arrested at least once. And over half of those people had said that all of their arrests were directly related to their trafficking. So we're hearing that 50%, about 40% of trafficking survivors, all of their criminal record was directly tied to their trafficking experience. In cases that I have worked, I have heard from survivors about the different ways that their abuse led to criminal charges. I've worked many cases of sex trafficking survivors who are forced to steal cars or commit armed robbery at times when they didn't make enough money for their trafficker in the club or selling sex. I've heard and supported youth labor trafficking survivors who were told to take the blame for drugs because their trafficker said they would have lesser punishment than the trafficker because they were an adult. And I have heard of child sex trafficking survivors and worked with them being punished for physically defending themselves against adult predators who purchase sex with them. These disturbing and gut-wrenching stories are common, and while some stories like that of Centoya Brown Long are lucky enough to make national news and shine a light on the injustice, the majority of these survivors that we serve have stories that never make it to public attention. Once a survivor has that criminal record, it becomes a barrier when they're attempting to access basic services and resources. Trying to serve survivors of human trafficking in Louisiana, my colleagues and I in the field are constantly struggling to find low barrier resources for clients because of their criminal records that happen because of their trafficking. Research studies have also confirmed that this is the case across the country and that long-term impacts from these arrests and convictions have major impacts on their lives. Polaris, the human trafficking hotlines manager, published a survey this year actually that highlighted that survivors said their criminal records prevented them from getting basic needs met like safe housing and employment. which meant that in many cases they felt they had to return to their trafficker. Another study found that 72.7% of survivors reported that this had created a barrier to employment, so they couldn't make money to serve themselves or access basics such as food stamps. This lack of access to resources to just get by and survive, meant that trafficking survivors often return to those abusers. If we want to prevent human trafficking, we need to consider that these records for all different survivors of sexual violence can lead to further trafficking. For example, if a domestic violence survivor is unable to get housing because she has a criminal record, she may be more likely to turn to a potentially abusive person or a trafficker who's offering her a safe place to sleep. The Louisiana Human Trafficking Prevention Commission and Advisory Board, of which I was the labor trafficking chair from 2018 to 2021, unanimously recommended this legislation for a reason. And that is because leading experts in the state of Louisiana know that protecting survivors from criminalization is a critical component to ending trafficking. I would be happy to share any of the studies that I mentioned today and would welcome any questions or conversation on this. And I want to thank you for your time and your consideration today.
Thank you for your testimony. So for the two that have already spoken, y'all can go ahead and clear the table. If there anyone else who wants to come up and who has put in a green card, is there anyone else out there who put in a green card and checked that you did want to speak? And if you did, you can go ahead and clear the table now. Okay. I have no questions for you. Thank you, though. So if you put a card in and you checked you wanted to speak, and if you want to waive, that's fine as well if you believe your points have been made by other witnesses. Okay. Let me start here. She just, we'll get her back. We'll get her back. She just left the. The lady here on the far right, why don't you go ahead and introduce yourself and give us your testimony, please?
Yes, my name is Connie Lewis. I am from Lake Charles, Louisiana, Calcasieu Parish, and I am here on behalf of Sergeant Kim D. Verdict. She's not able to be here today, so I'm going to read her testimony. And I'm just here as a support for Louisiana Survivors for Reform. So I am retired Detective Sergeant Kim D. Verdict, formerly of Vermilion Parish Sheriff's Department, where I served 20 years with 16 years as a detective sergeant. I am currently on the board of directors of the Louisiana Homicide Investigators Association, working closely with LA Post. I am also past president of the Vermilion Parish Domestic Abuse Intervention Program. It is with this background in law enforcement that I write this letter out of concern for victims of domestic violence and victim perpetrators who felt compelled out of fear for their own lives or the lives of someone else very dear to them to retaliate against their abusers. In my years in law enforcement, I had a bird's eye view of both sides of the horrible problem called domestic violence. One case that comes to mind in particular is a homicide case where a woman endured years and years of domestic violence that was well documented with the Sheriff's Department. When the abuse was brought out at trial by her defense attorney, it barely or not at all registered with the judge. It obviously had no bearing on the sentencing, as I believe she got the maximum sentence. At the time of the incident that pushed this victim perpetrator over the edge, the verbal abuse she suffered during the marriage began to overflow onto her beautiful grandson. Her husband began calling her their interracial grandson ugly names and making derogatory racial comments to the child and about the child. I believe that fear of the progression from verbal abuse to physical abuse like she suffered was cause of her actions. These are the kinds of frightening things that push a reasonable woman over the edge. We'll greatly like and support services and avenues for relief of these victims. It is with great sadness that I write this letter because I feel like so many victims are never given a chance for a second chance. I humbly request that SB 215 be considered with the greatest of urgency. Thank you.
Thank you for testimony. Yes, ma'am.
Okay. Thank you all for allowing me to speak. My name is Nyla Starks, and I am the eldest daughter of Tamika Starks, an incarcerated survivor of domestic violence. Today, I sit before you as a 22 years old young woman, mother, soon-to-be college graduate, and nonprofit founder. But my story goes far beyond what you bear witness to today. At the ripe age of 10, everything I knew was taken away from me. For years, I never understood why. As a young girl, I was ignorant of the secrets of intimacy in my mother and father's marriage. I saw love and unity, which every child desires most from their parents. But things weren't as picture perfect as I had imagined. My mother, like so many other women, had her own reason for not leaving my father. They shared 4 beautiful children together. Daddy was the breadwinner and Mama was the homemaker. At the end of the day, no matter what rageful spirit overtook my father in his moments of anger, my mother still loved him more than anything. He was her husband. I remember proudly telling all my peers and friends at school that my mother was so important that she was on an extended business trip, because that's what I believed. I was so proud of whatever work she was doing and knew I wanted to be like her when I grew up. But my excitement quickly turned to heartbreak when I learned from an older cousin that she was in prison and that my father's funeral occurred 1 week before and me and my siblings weren't there. Most children of incarcerated or absent parents find themselves raising themselves and their siblings as I did. But through my mother's faith and resilience, I grew to see her for what she was, a scared and desperate woman and mother who wanted her abuser to stop. These women are not animals or monsters. They're victims. They're survivors. They're our mothers, daughters, sisters, and friends. My mother has ample support when she comes home, but this is not the case for other women who have been deemed unfit for society and therefore cast out of their very own families. If this bill had already passed, then my mother would have been home to see her 4 children graduate and witness her first and only grandson being born.
Just take your time, and if you want to just stop, you can too.
If my mother had an advocate to educate her and those witnessing her trial on domestic violence, then she would have gotten the support she needed to lead a better life for herself and for her children. If the legal justice system believed my mother and listened to her the first, second, or even third time, then both my mother and father will be here, watching their babies grow into the best version of themselves. If we as a society had practical, preventative, and proactive measures, then we would not be reaching and racing for reactive ones. I leave you with this. Survivors should not be punished for surviving. And with your help in passing this bill, you can be part of a world in the future that believes just that. Thank you.
Thank you for your bravery for coming today and giving your testimony. Senator Barrow has a question for you.
Thank you, Mr. Chairman. I do not have a question. I just want to thank you for your courage. I want to thank you for sharing. I know that must have been extremely painful and difficult. And is your mama still?
Yes, yes, ma'am. She's in LCIW.
How much time she received?
She received, I believe, I don't remember the exact amount of years, but I know she went in 2010, and for good time release would be 2026. But she did file for clemency.
Okay. Well, keep your head up and keep doing what you're doing. Keep being a voice and an advocate is so important. Thank you.
Thank you.
Thank you, Senator Barrow. Yes, ma'am.
Good morning,
Good morning.
committee and Mr. Chairman. Can you hear me?
Can y'all pull the mic over a little bit?
Okay.
Thank you.
Thank
we can hear you now.
Okay. My name is Beatrice Taylor. I go by Beezy. Thank you for having me. I am a criminalized survivor of domestic violence. I served 23 years of a life sentence without parole in domestic self-defense, and I am one of the few to be released on clemency. In 1996, I had been a career professional for IBM, and then I was educated for 17 years to become a systems designer for telecommunication systems for the federal government, the Alcohol, Tobacco, Firearms, U.S. Marshal, DEA, all across Louisiana. The courthouse on Government Street was one I worked on also. My professional career was impeccable. I became involved briefly, a few months, with a man who concealed a long history of assaults on women, on police, kidnapping, failure to assist, fugitive from justice, and on and on. This was concealed at my trial, not handed over in discovery. I discovered it myself through U.S. Marshals and Bureau of Prisons while I was serving my life sentence. I knew this man for 1 month when I first called 911. After that, he would break into my apartment through windows, doors, deadbolts, and he would leave before the police responded. After 6 months, he did not leave in time, and they responded, and he was ordered to leave. He called me that night to say he had left his work boots behind, and I called 911 to ask what I should do. They said, do not antagonize him. At 6 a.m., he came to my apartment and forced his way in violently, pinning me against my kitchen window and threatening my life. I grabbed a kitchen knife from the counter to alter his attention and run around him to the open door. He grabbed me and turned me around to face him as I was backing out my front door on the second floor. He lunged at me with full force body weight and his fist raised to my face. I lifted my forearm to block his fist. His foot and body weight broke my toes, and the knife was still in my hand as he lunged. He chased me all the way to the stairs, which was about as far as your panel here. I ran on the broken toes about a block to call 911. I knew I was hurt. I served 23 years of my life sentence in ministry staff. I assembled 2 chapel libraries and a seminary library, working up to 7 days a week. I was a listening ear to anyone, including your mama. I was her librarian. My clemency is very rare. Most die striving for clemency. Now I serve their prison community for the 99 years of my parole community service. On behalf of some ladies who will otherwise die incarcerated, I would pray for the passage of Senate Bill 215 this year, which would ensure precise education of judges and juries on wrongful convictions like mine. Survivors should never have to choose between prison and death. Those ladies left behind deserve the same freedom and justice that I was given. I am grateful for it every day, and I thank each of you for listening.
Thank you for your testimony. I see no questions, so y'all may clear the table, and we have a few more people who'd like to speak and support. Then we'll hear from the other side. And if you want to wave, you're fine, but if you'd like to speak, that's fine as well. I've got 6 more cards that I. Okay, let me begin with the lady here to the right. If you could introduce yourself.
Sure. Hello. My name is Chloe Brubaker. I come to you today as a victim of intimate partner violence, although there's nothing intimate about it. First of all, thank you for hearing us today. It takes a very brave and kind soul to listen to survivors and victims. This is unpleasant material, and it's difficult to hear.
Oh, sure.
According to RAINN, 80% of adult rapes are perpetrated by someone the victim knows. I'm a victim of partner violence, including repeated rapes in multiple parishes. I didn't used to understand why a woman wouldn't immediately leave an abusive relationship, not until this last year. When I met the man who abused me, I was out for a burger and a beer. He approached me and soon told me that he was a successful psychologist, owned a martial arts school, where he instructed adults and children, and from a well-established family. We were soon boyfriend and girlfriend. Several years later, I dumped him. I began connecting the dots and subsequently had a nervous breakdown when I realized that I had been dating a serial rapist, psychopath with sadistic paraphilia, that he'd been abusing women for decades, and that he had been frequenting sex trafficking victims for at least 3 decades. How did I not see it? How did I not know? I have a degree from a good college. I have a good family. I'm very intelligent. How did I not see it? How did I ever think I loved him? I was deemed too stable after the nervous breakdown for psychiatric hospitalization. I was referred to a trauma-informed crisis therapist who I continue to see to this day. I've realized that he utilized his psychology education and training maliciously, not only on me, but on everyone he encounters, to present himself as a good man and a community leader. He used his education and training to destroy my confidence, isolate me from my family and my friends, and attempted to convince me that him strangling me was in my best interest. The first time he tried to strangle me, I said no immediately and swatted away his hand. I was raised that strangling is not an expression of love. I was shocked by the force of the impact because I was also raised not to hit people. He also date rape drugged me throughout the relationship. When I reported to the police, they let my rape report collect dust for 2 months until I called them for a progress report. After which, they made me report again in front of 5 men. The chief of police called the strangling autoerotic asphyxiation. When I looked up what that meant, a person choking themselves while masturbating, and corrected him, he told me, quote, "I don't need anyone second-guessing my knowledge of sex crimes." Obviously, he did. The detective who negligently investigated my report told me that the sex was consensual because the man gained pleasure from strangling me. Per policy, my report was sent to the DA's office. Essentially, all of law enforcement thought that I was crazy. Interestingly, seeming crazy is precisely one of the symptoms of being raped. During the 7 months that I battled the police for my dignity, to get the rapist masquerading as a community leader off the street and in prison where he belongs, I did my research on rape, rape myths, rape trauma syndrome, rape culture, victim shaming, victim blaming, victim silencing, ambivalent sexism, psychopaths, sociopaths, serial killers, most of whom are also serial rapists, psychological manipulation, grooming, and much more, all of which I sent to the police. I told them about the drugs and the guns in his house. My inquiries discovered 7 more victims and knowledge of dozens more. I informed the police of this. When one of the victims called the ADA reviewing my report, he was vehemently hostile with her and demanded she never contact him again. Meanwhile, the serial rapist, this very minute, continues to roam free and rape more women, as well as to intimidate me and other victims with cease and desist for defamation. He also stalked me. This is not the first time he has stalked a former victim. I am not the only person who would not be surprised to learn that he is a serial killer. You can see why I had a nervous breakdown. I made inquiries as well to the sheriff's office, the DA's office, and the attorney general's office in the parish that I had reported to. I was shocked to learn that very few of them have a grasp of consent. When she says no and he doesn't stop immediately, it's rape, period. Not all of the law enforcement, including the DA and the AG's office, seem to be aware of this. I was also told that the police department that I had reported to has a well-known history of improperly investigating sex crimes. I was also told, if you figure out how to make a cop do his job, let me know. The answer for this is simply firing and decertification, as Georgia does, but that's another topic. I reported him raping me in another parish. These police were much more educated on rape trauma and what it's like for a victim of a sex crime. This time, they correctly and promptly determined that I am a sex crime victim. They assigned me a social worker who suggested that I go get my neck checked for permanent strangulation damage. I have been in physical therapy for 2 months for said damages and continuing. I am forever grateful for these police. Because of the first law enforcement that I reported to, the DA's and the judge's lack of will to protect victims, their shameful and blatant refusal to learn information regarding sex crime and its effects on victims, their families, and the community at large. We absolutely need the right to expert testimony concerning the impact of psychological and emotional manipulations and sexual abuse on a victim's state of mind. We need to open avenues of defense that victims are currently denied. The law needs to support and protect victims and survivors, not condone law enforcement's bullying and abusing us. Every drop of shame belongs on the rapists and those who harbor them. Not one drop of shame belongs on the victim. They have done nothing wrong. If the rapist had not raped them, they would not have been raped. If the man had not abused them, they would not have been abused, period. Please do not allow those whose sworn duty it is to protect the public to further abuse and traumatize victims. I don't know if any of you have read articles on what some of the DAs across the state have been saying. Things like, she's not a victim because she doesn't act like a victim. They should be embarrassed of themselves, and it's shameful. And I understand why they're opposed to this bill, because it will be embarrassing for them. However, as human beings, we have to care about one another and take care of one another, even if we are a little embarrassed sometimes. Voting yes on 215 will let law enforcement and the criminal justice system know that Louisiana legislators have made it clear that victims and survivors need to be treated with professionalism, dignity, and respect. Vote yes on 215. Thank you so much for your time.
Thank you for your testimony. Go ahead, please, ma'am. If y'all could once again try to keep it to less than 5 minutes, just because I have a lot of people who want to speak.
Absolutely. Thank you for allowing me to speak today. I do promise to be brief.
Thank you.
My name is Gabrielle Perry. I'm an epidemiologist, a lifelong Louisiana resident, a survivor of stalking, and the founder and executive director of the Thurman Perry Foundation. I'm also a formerly incarcerated woman, as well as the daughter of a formerly incarcerated woman. And I speak today in support of Senate Bill 215 and the incarcerated women across the state of Louisiana, whom it would directly impact. Louisiana incarcerates the most women per capita in the entirety of the developed world, more than all of our NATO allies combined. Yet, the resources, aid, legislation, even the public outcry around criminal justice and incarceration in Louisiana solely has a male face. As a society, we do not discuss how incarceration impacts women unless it is from an entertainment or true crime point of view. Speaking as an epidemiologist, it is not that women commit different crimes than men. Statistically, they are convicted of roughly the same crimes as them. But the why is different, and the why does matter. Current stand your ground statutes are too ambiguous and not successful in protecting victims of domestic violence, as they are very often applied to those whose attackers were strangers. Because of this, the state of Louisiana is burying women above ground and calling it public safety and progress. Because we currently and legislatively ignore the why, 80% of incarcerated women are domestic abuse survivors. 68% are survivors of child abuse, and 75% are survivors of sexual assault. Because we ignore the why, we give women an impossible choice. You can either die at the hands of your abuser or inside an 8x6 prison cell. As a formerly incarcerated woman, I've experienced firsthand the lack of support by law enforcement and other agencies for women escaping any kind of violence in the state of Louisiana, which makes the frequently used mantra of "why didn't she just leave" an ineffective and callous battle cry of any and all who would oppose this bill. From personal experience, my now deceased birth mother left a toxic relationship, and she was rewarded for her courage with homelessness and a subsequent jail sentence that took her from all 5 of her children, including me, whom she gave away to total strangers on the day I was born to try and spare me her same fate. As the executive director of an organization dedicated specifically to the women this bill would impact, I ask that it be given the highest consideration. In 2.5 years, we have aided almost 3,000 women at the Thurman Perry Foundation, one of whom you just heard speak in committee today, along with her incarcerated mother, who is one of the most profound people I have ever met in my life. And most who are housed in LCIW, Orleans Parish Prison, and East Baton Rouge Parish Prison, where I myself was incarcerated, and whom we maintain an excellent working relationship to support the women they house. We have awarded second chance scholarships to allow these women to continue their education even behind bars. We provide rent and mortgage relief, as we are the only organization in Louisiana providing direct housing assistance to formerly incarcerated pregnant women and mothers. And we offer other necessities and not only dignify these women, but serve as assurance that they can successfully reintegrate into society. What you see today before you is a community standing at the ready to support our mothers, our sisters, our wives, our daughters, and our friends in rebuilding their lives and keeping Louisiana safe. It is my sincerest, most heartfelt ask that you stand with us and pass the Justice for Survivors Act. Thank you.
Thank you for your testimony. Yes, ma'am.
Hi, I am Letitia Payton, Executive Director of the Tent Makers of Louisiana. My organization helps survivors of clergy sex abuse to find healing, justice, life, and joy. I am here to support SB 215, the Justice for Survivors Act. We have all been affected by sexual abuse or violence, either as a child, a sister, a mother, or a friend, someone in our community. 1 in 5 girls experience sexual abuse before the age of 18, and 1 in 13 boys experience sexual abuse before the age of 18. These people are our children, our brothers, our sisters, our mothers. The Survivors Act seeks to prevent the criminalization of survivors of abuse, coercion, trafficking, and violence by providing an avenue to present the context of the direct connection between the commission of a crime and the defendant's related victimization. Dr. Colin Ross, creator of the Trauma Recovery Program, says, "Trauma recovery is a significant problem in our society that does not receive the attention, funding, research, or priority that it deserves. The effects of unresolved childhood trauma make a major contribution to many social problems," unquote. To understand victim behavior, we need to understand better their trauma and how it relates to the problems we face in society today. The same goes for perpetrators who continually re-victimize others. Our families, children, and communities deserve a safe place to live, and we also need to be able to defend ourselves against violence of all types. I support SB 215 because it requires a direct connection between the trauma a defendant suffered and the trauma the defendant inflicted on someone else. Thank you.
Thank you for your testimony. I'm sorry, Senator Barrow has a question.
Really quickly, the gentleman that actually violated you, is he still
roaming free and raping other women? Yes.
In the state of Louisiana?
Yes, ma'am. And I understand, people usually say go to your representative. However, we do have a thing called roads.
Called what?
Roads.
Roads.
As in, rapists can travel to other parishes.
Mm.
Yes, ma'am.
Okay. Thank you.
Yeah.
Thank you, Senator Barrow. Senator Mizell.
Thank you, Mr. Chairman. I wanted to ask, and I know we've got a time constraint here,
Yes,
but
ma'am.
was a rape kit done? Is his DNA on file somewhere? Do you know?
I sure hope so. As far as I know, I am the only victim who has stepped forward. With the complexities, with law enforcement not understanding the complexities or having the will to understand but the complexities, at least in my example with the first, like I said, the second, they were fantastic. And like I said, I am forever grateful to them.
I was just wondering because, when you said it was serious, it's like, okay,
Yeah.
are we able to track his DNA to the other victims, or if his DNA is not on file, then he, I left here to pass a rape kit bill, and in the rape kit bill, but you're validating the discussion, so I just was curious.
Personally, I have kept things with his DNA on it, just in case. As I understand it,
Somebody's got to have it on file.
Yeah. Also, as I understand, with the backlog of rape kits, at this point, processing rape kits is not a guarantee because they often sit there until the DNA degrades.
Right.
So.
Thank you.
Thank you.
Mr.
Thank you, Senator. Okay, we have no further questions. Thank you for your testimony. I have 3 more people here in support who'd like to speak. If you still want to testify, come on up, and then we're going to go ahead and hear from the other side so we can go ahead and vote. Go ahead and introduce yourselves, please. We'll start here from the lady here at the right.
Sure.
And go ahead and provide your testimony.
Thank you. Good afternoon. My name is Mariah Wineski. I'm the Executive Director of the Louisiana Coalition Against Domestic Violence. We are the statewide network of domestic violence shelters and service providers in Louisiana. We are here in support of this bill because we believe that it will provide opportunities for our justice system to better understand the totality of survivors' experiences. So in our work with thousands of domestic violence survivors, unfortunately, we see many of them who are arrested, charged, and convicted of crimes that are directly related to the abuse that they experienced, like many that you've heard from today. Many times they're coerced by their abuser to participate in a crime, or in some extreme cases, survivors end up spending many years or the rest of their lives in prison for saving their own lives. So in our experience in helping survivors navigate these circumstances when they face them, we have seen that our criminal justice system as it currently stands really is not set up to understand the dynamics of domestic abuse. Domestic abuse is this pattern of coercive and controlling behaviors, but our legal system, of course, is focused on one incident and one snapshot in time, a lot of times without taking into account the circumstances that led up to that moment. And then unfortunately, we do know that the myths about domestic violence that kind of circulate in the general public also permeate our legal system many times. And these myths are the things like, real victims act a certain way. If she were a real victim, she would have just left, or she should have just left. The abuse goes both ways, those types of things. And the end result is that we have many survivors who are serving time for saving their own lives. So this bill, in our mind, creates pathways for survivors to be able to inform the court about their circumstances and the totality of those circumstances. Because domestic abuse is really all about those circumstances and the context. So it's important for survivors to have the ability to present that context and truly explain themselves. The other thing that we see is that a lot of survivors are reluctant to participate in the criminal justice process at all. Many survivors don't want to testify. Many survivors don't want to call the police because they're afraid that they will face charges as well. And that fear is definitely justified because they often do face charges as well. And in the end, that is contributing to really high homicide rates that we have in Louisiana. And it makes the job of the prosecution that much harder when you have survivors who are reluctant to participate. So we see this legislation as an opportunity to address some of these issues. It's a chance for us to do the right thing and to hear from survivors who have not historically been able to tell their stories. It's also a chance to create pathways within the criminal justice process for survivors to present the full context of their experiences. And we believe that if there are opportunities for us to adjust our criminal justice processes to allow for that better understanding of domestic abuse and its effects, then we will have survivors more willing to engage with that process in the first place, which is going to make it more effective in promoting public safety. So it is our hope that you will support this bill in an effort to help build that justice system that is truly responsive to survivors.
Thank you for your testimony. Please go ahead, Ms. Lamondre.
Morgan Lamondre with STAR, and I have worked for STAR over 10 years now, and I've been coming to the Capitol for about 8. And in those years, I've come before you all asking to pass various measures to help support sexual assault survivors. We've made so much progress, but behind all of that progress, as we still all the time, Senator Barrow and Senator Mizell, I thank you all for your leadership on continuing to try to address these issues. But what we're seeing is that we do not have a state that takes care of victims. They don't. And every time we come here, we think we're doing better. We're passing more legislation. But a lot of times what this all boils down to is believability and what is a real victim and the perception that in the criminal legal system, and I deliberately say criminal legal system rather than criminal justice system, is because we know justice is not always obtained in the criminal legal system. But I think that, when we're dealing with survivors, just like we try to educate people on what a perpetrator looks like, survivors look many different ways. They come in many forms. And when you're constantly up against a system that does not take care of you, does not help you, does not support you, does not believe you, sometimes survivors do take matters into their own hands. And we know that from sort of history, being at the Capitol and supporting certain legislation, we're always told the parade of horribles about what a bill may or may not do. But a lot of times that is extreme measures. I think with amendments to this bill, there are certain things that are going to be addressed that, if you hear the parade of horribles, to really push back and question what that looks like. How is this going to be implemented? Because in the end, this is not a get out of free jail card. It's not. It's just an opportunity to present the truth, the entire truth. And that is what we're supposed to strive for in the criminal legal system, where we need to hear the entire truth. And this is just merely that opportunity to hear all of the truth. It does not mean that a jury will, in the end, buy into whatever that truth may be for the survivors that are presenting it. So I don't want anybody to think this is just we're going to be letting everyone loose, because the truth is it doesn't affect many people who are already in prison. And then for moving forward, it's just not going to have the effect that people think that you're going to have the effect, because the truth is society, even if we get to the jury box and can present all of the information, society has not also been put into a position where they completely support or understand the dynamics of sexual violence, domestic violence, and trafficking. We still have a lot of work to do. So thank you.
Thank you. You must be Ms. Sharp.
Yes, that's
Okay.
me.
Thank you. You could wrap us up.
Absolutely. Thanks for having us this afternoon. My name is Natalie Sharp. I'm an advocate with Louisiana Survivors for Reform. I'm here to read a letter on behalf of someone who couldn't be here today. Miss Theolonia Champagne works at the Louisiana Correctional Institute for Women. She actually teaches a class for survivors of violence for the incarcerated women. And there are women in this room who have been in that class. And so she wanted to share some words today. I, Theolonia Champagne, am a survivor of domestic violence. Domestic abuse was the worst thing I'd experienced in life. I held onto this horrible secret for over 17 years from my family. I finally broke the silence. I was finally ready to talk about it. I was still angry, bitter, and emotionally scarred, but I was willing to help others. I've been advocating for domestic abuse survivors since 2005, when on June 9th, 2007, my daughter, Yarnell Gage, was murdered. The very thing I was fighting against killed my daughter. She was murdered by her husband as a result of domestic violence. There are no words to describe that pain of losing someone so near and dear. In 2019, I started facilitating my sister's keeper at LCIW, and that is a blessing from heaven. The women and the men are so receptive. This is my passion, and it aids in my healing. The pain of losing my daughter will never go away. Every day I learn how to cope. It does my heart good to hear the women say, "Miss Champagne, I love your class. Can I take it again?" My goal is to reach out further into the world to educate about domestic violence.
Thank you. Okay. So we have anybody else? I can't remember if we have. I think that was it on the green cards. Thank y'all. Appreciate it. Very moving. We have opposition. These are cards that are present and would like to speak. I don't know who wants to go first. I guess I'll just call them out. Bridget, excuse me if I mispronounce your name, Dimvault? Yes, sir. Would you like to speak? Representing, I guess, the DAs.
Good afternoon, Senators. Thank you for this opportunity. My name is Bridget A. Denvaux. I am the current president of the Louisiana District Attorneys Association. And I am representing the association. But before I do, I'd like to commend all of the speakers who support this bill on their courage and bravery for speaking out. What is really important about today is that our opposition is not against the survivors or the victims of domestic violence. It's a very serious and it's a very devastating issue, along with human trafficking. We realize that and we see it every day because we're working boots on the ground. What we'd like to do is continue to work. Up until yesterday, I think yesterday evening was the last email that I received, that there were constant communication between both sides. And I do think we need to agree and we need to come to a common ground on how we move forward to address these issues. And so that's what's really important. I don't want to stop communication. I don't want to stop the back and forth talking about this because it is important. It's important for us because we are responsible for prosecuting crimes in our respective jurisdictions. We do have to do that. We want to be able to work with survivors of domestic violence, even though they may be sitting at the other side of the table. They may be sitting at the defendant's table, where we're sitting at the prosecution table with other victims, because especially when we talk about a situation where there's a murder involved, we are sitting at a table where we have other victims as well, families that are concerned about the person that they lost. So this is a very serious issue, and it's a very important issue, and it's something that we do have to work on. And I would just like to say that we would like to continue to work on this and come up with something that's going to work for the state of Louisiana. And so that's why I'm here to speak on it. Thank you very much.
Thank you. Thank you. I appreciate it. Next, do we have, I'm sorry. I have a question. Ms. Denval? I'm sorry. I excuse you. I didn't see we had a question here. Senator Barrow.
Yes, ma'am.
Denvold?
Denvold.
Yes,
ma'am.
Ms. Denvold. This is my first time actually speaking with you. I don't think I've had the opportunity to speak with you on this bill.
Oh, no, ma'am. No, not at all. Yes.
That's that. And I want to make sure that I clarify that. I am very open to keeping the lines of communications open.
Yes, ma'am.
I'm very open to working through any trepidations or things that you guys feel will be unintended consequences, because that is not my intent.
Yes,
my
ma'am.
intent is really to bring justice to those women who did not have an opportunity to have their full case disclosed, and for those in going to court to make sure that that information is being able to be brought to and introduced
Yes.
as part of their defense. So I am open to that, and if we are able to get the bill out of committee, I look forward to continuing that communication.
Thank you very much. I appreciate it.
Thank you.
Thank you. The next person here wishing to speak in opposition is Jacob Johnson and Dana Cummins. If y'all can come up, if y'all still like to speak. And then also Hope Burford, if you're here, Hope.
Chairman, I'll go ahead and take Ms. Buford's for her. She's from my office as well, just in the interest of time.
I appreciate that. Go ahead.
Thank you, Mr. Chairman and members. And I got a chance to speak with Senator Barrow for the first time on Friday on our video call, and I really appreciated that. Your work is something I've truly admired for some time. I can tell you I've had the privilege of being a prosecutor in Calcasieu Parish. I have the privilege of serving as the ADA board president. And the ADAs that I work with and represent care about victims more than anything else. And that's why they do this work. They don't do it to get rich. They do it day in and day out, and they grind. And sometimes they deal with fact patterns where they very much believe someone's been victimized but can't quite prove it. And those are the toughest cases of all. I do appreciate that this bill has been amended from where it previously was, which was that could apply to anybody, not just domestic violence and trafficking victims. And that appears to have been addressed on the justification piece, the new justification defense type piece. But one thing that is very concerning to me, and we'll see where we go from here, but currently the post-conviction relief amendment doesn't limit that in any way to the victim of that crime having been the perpetrator of abuse, and where that really could be a whole lot more than this small universe of people is, I can tell you, 2/3 of folks on death row certainly have put on mitigation cases where they've had tales of child abuse. Now, that had nothing to do with the murder that got them to death row, but this will be that will be one of the first hammers they use to attack this. That's really concerning for us as prosecutors, but I know absolutely that Senator Barrow's heart's in the right place here. What I can tell you is another piece that is concerning is the expert piece. I want to make sure that anything we do on this bill when it comes to experts requires the expert to be qualified under the law, not language that would show that he shall be admitted as an expert. That's concerning. Here, previously, the district attorneys had proposed an alternate bill some months back that, for example, would allow murder to downgrade into manslaughter. Currently, there is Dorothy that applies to every single case. And I'll tell you, a lot of what we heard today was moving. It was impactful. It impacted me. Look, tales like that are why I've served on my women's shelter board locally. Tales like that are why I'm involved in our human trafficking task force. Tales like that are why Thursday, as we were sitting here, I committed to going to a sexual assault survivors event in my city. But a lot of what was presented didn't have anything to do with this particular bill. Experts in self-defense cases have been available to defendants forever. That didn't just change in 2018. In 2018, the Louisiana Supreme Court was very clear that the Curley decision was reiterating long-held law. There wasn't anything to make retroactive because it was not new law. Self-defense experts have always been available to people who are charged with crimes. And there's always been available post-conviction relief grounds for people whose lawyers did not explore that possibility. That's not a new development. Self-defense has always been a valid justification to a crime, and those experts have always been available. This type of expertise is something that expands that quite a bit. And further, the post-conviction piece that I'm a little bit worried about, we tend to get away from that direct language, and we then go into a significant contributing factor to a defendant's participation in an offense. That's a whole lot broader than the direct cause of someone's criminal action. So currently the PCR piece is not limited to crimes on which the perpetrator of prior abuse is the victim. That swings the door wide open there. And the expert piece is greatly expanded from the direct cause. So that is extremely concerning, just as a trial prosecutor, as someone who deals with this for a living. And currently in the law, and this has been, I know, frustrating to some of the people with the DA's Association who have worked on this piece, is we've heard that there are 30 to 40 people or so that this applies to. We have requested a list of those names, because we said, let's dive into those. Let's dive into those for resentencing consideration. Let's dive into those to see if there's a wrong that we can right. A response email was, that's not our job, you should be doing that. And so that makes it very frustrating and very challenging to try to dive into those. I can tell you, I had a conversation with a gentleman who's involved, and I know his heart is in the right place, and he's on the opposite side of the bill than me. I know his heart's in the right place, and I told him before we began, look, if you've got some of these in Lake Charles, come to me and let me look at them. And I mean that. Let me look at them. We have those mechanisms already in the law under 930.10, but we do have concerns about the overbreath here. But again, I know absolutely that Senator Barrow is trying to attack an issue, and we want to work with her to the extent we can.
Thank you for your testimony, Ms. Cummings. I'm sorry, Senator Abraham, you want to ask Mr. Johnson?
Yes.
Yes, sir.
Okay, I know I'm not going to get you to repeat yourself, but in one way I am. You said that the expert witness was a problem?
In the post-conviction piece,
post-conviction?
Senator,
go ahead.
Currently, the justification piece says that the expert that would be available for this expanded justification type defense would be that they would be opining that the defendant's conduct is a direct result of that intimate partner violence, domestic abuse, or sexual assault. However, the post-conviction relief language seems to get away from that a bit, and I was texting with some folks who do this for a living while I was here. That deals with a rational relationship, which is not a direct relationship, and I want to make sure I don't misspeak.
You saying that's
here,
not
Senator.
a direct relationship to domestic violence? Is that what you're trying to say?
That's what I'm concerned about, Senator. I'm sorry, I'm used to saying judge. I almost said that's what I'm concerned about, Judge. I'm used to saying judge and Your Honor. So if you want me to say Your Honor, Your Honor. But that's a concern of mine, and
he would like
trying
that
to find
actually.
through my,
yeah,
he would. There you go. Yes, sir.
And then you said something about swinging the door on open.
That's
trying to write it down.
yes, sir. So the post-conviction piece currently does not have any limitation, as I understand the amendment that was put onto the bill this morning. The post-conviction piece does not have any requirement that, so if someone is serving time for murder and they want to apply for post-conviction based on being the prior victim of domestic abuse as at the hands of the person who's deceased. Well, that's one thing. Again, self-defense has long been part of the law, and that's not being dealt with here. That was already part of the law. But the post-conviction piece here doesn't require at all that the victim of the crime for which someone was convicted be the prior abuser of the person who is incarcerated. So that's what I'm concerned with. I have great concerns.
Why is that a concern? Why is that?
For example,
what does that do legally?
Legally, what that would allow, Senator, would be that one could apply for post-conviction relief for the killing of a person who is not their abuser. Right. That's what I'm concerned about. Under the current amendment that was put on this morning, one can say, I acted in a fashion that was caused by prior abuse, but the deceased victim had nothing to do with that prior abuse. So that's what I'm.
How can we correct that?
Well, it could be corrected if some of the language was adopted from the new justification piece. I don't have that amendment, but I can tell you what was greatly concerning initially was that this bill applied to everyone under the sun, and I know that wasn't the senator's ambition. I know that, but the post-conviction piece doesn't have that requirement that the victim of the crime for which someone is convicted had anything to do with any prior
I
abuse.
agree with you on that. Okay, well, that's one part. Maybe you can work with the author on it.
Yes, sir.
Okay, thank you.
Thank you, Ms. Cummings, please.
Good afternoon, Your Honors.
Thank you.
My name's Dana Cummings. I'm the Chief of Litigation at the East Baton Rouge DA's office. I've been there 29 years. I feel that my life's work has been to serve the needs of victims. That's why I got into this, and that's why many people in my office are prosecuting, because they do want to do that. I hate that we're on opposite sides of the aisles of all these victims in this room, because that's where our heart is. When I was listening to everybody's testimony, it struck me that a lot of the things that these people that have been through horrible events and have suffered terribly, but a lot of those things don't have anything to do with this bill. I join Jacob Johnson in that, I think everybody's heart is in the right place, and I think we're all trying to get to the right place. And there are improvements that were made this morning, but we still have that concern, particularly the PCR concern. And I do have a small story to tell you all about that so that it will bring it home. I prosecuted a man named Decarius Holliday for the first-degree murder of a 2.5-year-old toddler back in 2009. And it was a horrendous case, and he... On that 2.5-year-old toddler's little body, there were 75 bruises. He had a bite mark on his foot. He had some sexual injuries as well. And it was horrific. It was horrible. And we tried that. That is the only case other than Derek Toddley that I've ever tried for death penalty. And we tried that case, and the jury did decide the death penalty was appropriate. But during that penalty phase, what we heard was that Decarius Holliday had been victimized as a child of both physical and sexual abuse. And I think that goes to Jacob Johnson's concern with the PCR, because under the terms of this, he would be eligible to file that petition to have his conviction at least considered. And that is not the intent here. The intent here is to take care of the victims who have been forced and being put in a position of having to defend themselves. And so that is my concern, and I did want to relay that. One other thing, I feel that there is law that says you can call an expert witness in these cases. And I would refer you to Code of Evidence 404A. And in that it says if the claim is self-defense, and you don't have to prove it like an overt act on the defendant, but if your claim is self-defense, you can bring up all the previous occasions that you've been abused or hurt by this person, and you can hire an expert to talk about the effects of this abuse and the state of mind. So I think that is actually there. I think the complaints are, one, we've come a long way as a society in recognizing that we've got to do better on domestic abuse. We have just come a really long way. And I think we've come a long way in protecting women's rights. And we've got ways to go, but we're doing it. And I think that's very important. I think the complaints are the judicial system didn't work for me this time. Some individual didn't do what they should have done. We've got the framework to do it, I believe. I just believe that all these tragedies are that people didn't do their job the right way that they should have. And that's that part of it. I agree with Mr. Johnson that the DAs, I know Hiller Moore is willing to look at these 30 to 40 cases, and there is a remedy under 930.10 to downward depart if that is what needs to be after the facts are considered. I think we have the framework to work in. I think that we've come a long way. I think we need to keep working together, and we certainly want to work because, like I said, we don't do this for the money, believe me. We don't do it for the money. We are here because we care about our victims. We want the judicial system to work, and anything that we can do to help, we want to do that. And we do appreciate Senator Barrow and Senator Mizell's efforts in this. I think it's just when it's such a big bill. It's such a big bill. It's taken me weeks to try to wrap my mind around it.
Well, I appreciate both of you coming in your service to the state of Louisiana. You've made some good points for us to consider, so thank you for your testimony today. Okay, the good news is, members, we have no one else wishing to speak, but we do have a few more cards in opposition I need to read. Kathleen Heap, Billy Joe Harrington, Perry Nicosia, Bradley Burgett, Bo Due, Michael Renatza, Scott Perilou, Lauren Lambert, Melanie Fields, Reed Walters, and Warren Montgomery. Judge Ansardi is here for information only, as well as Stas Moore. Those are all the cards I have. Senator Mero, I'll let you close it up and make a motion if you'd like.
Yes, I'm going to ask Stas if he would come as a part of my closing, Mr. Chair, if that's okay. And I would withhold any comments. I'll make just maybe one sentence of a comment after he finishes.
Yes, thank you, Senators. I could just, I think, address some concerns that we heard from some of the district attorneys. First, my office represents these survivors. We do go to DAs. We go to them all the time. We tell them about the abuse. What we hear is, those cases are old. We're not going to look at them again. We've done that through offices across the state, and it has fallen on deaf ears. Second, this has nothing to do with letting out serial killers or people on death row or whatever they're talking about. Mr. Johnson said that some people might bring up this legislation in cases where it has nothing to do with abuse. If it has nothing to do with abuse, if someone's conduct has nothing to do with the abuse, the legislation does not apply. People can always file pleadings or motions in court, and judges will dismiss them in a second. This law wouldn't have anything to do with those cases. Third, this post-conviction relief situation they're talking about, I think maybe perhaps some of the DAs haven't seen the new amendment. I think that Senator Barrow worked on. This new justification law would not apply retroactively under this new amendment. That would not be part of this. It would just be for situations where under the law at the time of the charge, it would be under the law at the time when someone, is accused of the crime or got arrested, if their attorney didn't consult with an expert or bring in significant evidence about the abuse, or if the trial, if there was argument or evidence at trial that relied on stereotypes about victims, this new justification defense under the amendments would not apply retroactively. It would just be an opportunity to say, under the laws back then, if the attorney had consulted with an expert, which they didn't do, the result would have been different. And which is exactly what Ms. Curley did, who was exonerated. The problem is most women in prison that can't afford attorneys. You don't get an attorney for your appeal once your conviction is final. And people weren't bringing claims about not having experts because it wasn't until Ms. Curley's case that someone actually won a claim that their attorney was ineffective because there wasn't an expert. Again, in terms of the numbers it would affect, under a similar law in New York that has a larger prison population, over the last 4 years, only 40 people got out. None of these sort of outlandish situations that we're hearing about. Just to kind of, I guess, bring it home and I can answer any questions. We're talking about like BZ right here. We went to the district attorney's office. They said they didn't want to negotiate her case. She came up for clemency. They opposed her clemency. And so I know we've been working on this for 2 years. There have been 2 task forces. There have been opportunities to draft things, to get involved, and everything we get back from the district attorney's office doesn't actually meaningfully change anything in the status quo. BZ's still serving a sentence for second-degree murder. She has a 99-year sentence. She's going to be on parole for over 70 more years. We are having our parole officers supervise her when she is at home in a wheelchair. So this is a really common sense solution. We can use the money that we're spending on incarcerating survivors to protect survivors instead.
So let me let Senator Klein, Peter, I think he had a comment or a question for you real quick.
Thank you, Mr. Chairman. No, whatever the outcome might be of this bill on this committee, I want to look at all of you all and commend you all for the courage that y'all had to stand in front of us and speak about what happened to y'all. So thank y'all for coming up here. We hear y'all, and I just wanted to let y'all know we appreciate it. Thank you, Mr. Chair.
Thank you, Senator Klein, Peter. Let me turn it back over to Senator Barrow if she wants to wrap it up and make a motion.
Yes, I do. And I'm going to keep it short because we have been here so long. First of all, I want to concur as Senator Klein Peter and thank all of the individuals who are here and those who have spoke and who had the courage to come and speak and share their stories. It took a lot of courage to do that. But everybody in this audience, I believe, have something to say or could have made comments. One of the things that I just want to say in closing is that we didn't have any males to come up and testify, but that doesn't mean that we don't have victims. They just oftentimes don't feel comfortable enough because of how society have made and painted the situation. We have to do better. This certainly is a step in the right direction. I believe Ms. Lamondre said it best. This is not a get out of jail free card. There is still going to be a lengthy process that individuals have to follow. And so with that said, members, I am committed to continuing to work with the DAs and anyone else who have concerns about this bill. We have narrowed it to as narrow I think it can be. I don't know if it can get much narrower, but I am still open to working with individuals on the bill because we owe not just these ladies that we've heard from today, but many more who could not be here, many more who don't have the courage to come and share their stories, many more who are just ashamed and don't want anybody to know who they are. We owe them. So with that said, members, I'm asking that Senate Bill 215 be reported as amended.
Okay, Senator Barrow, before we vote on your amendment, I think Senator Abraham just wanted to make one quick comment. Very quick.
Yes, I know you're going to work with them going to the floor. I'm still unclear on what the gentleman just said and what Jacob Johnson said about the abuse versus the abuser. So I think we need to straighten that out. Anyway, okay, thank you.
All right, members. Senator Barrow has moved that we report Senate Bill 215 as amended. Any objections? Seeing no objections, Senate Bill 215 is amended. Senator Barrow moves that we adjourn without objection, so ordered. Thank you, members.